evening, everybody. Welcome to the second BCS Law SG event of the year and the last one. We've got a good one, I think. So we've got very lucky to have Professor Andy Piffin, who's going to speak to us today. He's going to speak to us on the legal and social challenges for adults and minors. He'll look at the sort of legal and technical challenges related to image-based abuse and non-consensual sharing of intimate images. Sounds quite racy, Andy. It's based on a newly published book, and Andy will sort of explore the key issues in supporting victims and look at sort of the social and legal perspectives and how this might be tackled. He'll look at sort of the current sort of legislative mess, so to speak, around protecting and prosecuting minors for engaging in these practices. Now, Andy is regarded as a real expert in this area. He's a professor of digital rights at Bournemouth University and a visiting professor in the University of Suffolk. He specialised in this area in ICT and social context and the intersection of legislation for over 15 years, doing a lot of research in relation to the attitudes towards privacy and data protection, internet safety, and other issues such as sexting, peer abuse, and the impact of digital technology on well-being. He's also written and provided oral evidence to parliamentary inquiries and is a frequent media commentator on these issues. So we are really fortunate to have him, and on a personal level, I'm pleased to say he's also on our committee, so it adds a lot of value there. And yeah, so I'll leave it to Andy to continue. But before I do that, I unfortunately can't stay till the end. So I wish you all a very happy, festive, and safe Christmas break. We've got an exciting program in 2021, which you'll find out soon. So I will leave it to Andy, but Panajota will, who is our secretary of the committee, will be sort of facilitating the Q&A and will be wrapping up. But yeah, without further ado, I will turn my camera off and go unmuted and let Professor Piffin do his stuff. Thanks, Andy.
Thanks, Sam. I'm also going to switch my camera off, mainly because in order to be able to read my slides in my advancing years, I'm going to have to get quite close to the screen, and you really don't want to be seeing that while I'm delivering the presentation. So yes, the first thing I should sort of state is that this is my email address. This is the kind of issue that sometimes people have questions immediately, or sometimes people sort of cogitate on it and think about it. I am sure for the whole festive period I will be online. I seem to constantly be online anyway. If people do want to send me emails to ask questions, to chat and those sorts of things, you are very welcome to. So probably one of the most important things is the email address there. I'll also have it up at the end. If people do want a copy of the slides, then again, if you just send me an email, I'm happy to share the slides, or we can share the slides via BCS as well. So Sam's given me a lovely introduction there. A few other details. My background is actually in computer science, which is quite unusual for academics in this area. A lot of academics in this area come from the sort of sociology and social psychology side of things. Really, I got into this area because I did my PhD sort of on a pan-European sort of comms project. I was doing work in AI labs and similar, and starting to see increasingly interesting ethical challenges, which is how I kind of moved into this area. The difference, I guess, in bringing a computer science background to this area is when you do get some interesting government proposals in terms of how industry might need to sort these sorts of things out, you can at least do a little bit of pushback and explain why just because you say it's technically possible doesn't actually mean that it is technically possible. And that is something I'm going to sort of pick up toward the end of this talk in terms of some of the political rhetoric around this. I've been involved with the BCS for a long time now. I was on academic accreditations committee for a long time. I work with the policy guys. I do work around the education side of things as well. But really, as Sam said, I've kind of spent longer than I care to admit looking at these sorts of issues for quite a while now, probably starting around 2005, 2006. And what's kind of interesting is that none of the issues I was talking about then really have been solved. And as I'll explain as I'm going through this, I started really in this area, which I'll broadly refer to as image-based abuse, in around 2009. And when I bring the talk to a close, I think I will be reflecting upon the fact that looking at recent political rhetoric and also looking at where parliamentary inquiry is going, it really does seem like we've really got very far. I have jokingly said in the past, if by the time I retire we can actually change the legislation so it protects rather than criminalises children, it will be a career well done, but I won't hold my breath either. So the agenda, rather fortunately, I'm not sure whether fortunate's the right word, the online harms, well, the DCMS response to the online harms consultation came out at the start of the week. And it's an interesting thing to reflect upon. I'm not going to spend a huge amount of time sort of looking at it, but it's an interesting thing to reflect upon, because we need to bear in mind that that is the legislative intention of government in terms of addressing all of these issues, which one might broadly refer to as online safeguarding. And it's become increasingly frustrating from an academic perspective to see that the vast majority of the legislative intention is almost entirely focused on what the industry can do. I'll come back to that in a little while, but there are some fairly intangible discussions around this concept of duty of care, which I'm sure will have negligence lawyers licking their lips, because it is really quite poorly thought out in terms of how you actually place that into a legislative context. So I'll reflect a little bit on online harms, and I'll come back to that towards the end. I'm going to start off by looking at, if you like, the adult perspective on image-based abuse, which is sometimes referred to as revenge pornography. I'll talk a little bit about this, but essentially what we're talking about in this whole talk is someone produces an intimate image, they send it to somebody, and then that somebody will generally share it with others, generally in a non-consensual manner, and the resultant abuse that occurs from that. So while terms like revenge pornography have emerged from media discourse in the last few years, they are quite problematic terms in themselves, and the flip side of that, which is teen sexting, which is what some people use to refer to the similar behavior amongst people below the age of majority. Again, as I was told by some young people a while ago, the only people who use the word sexting are people over 40, which obviously, as someone who still thinks they're hip and cool and down with the kids, was quite crushing to hear. But it is those things where we think we are engaging in this discourse at one level, but actually when we looking at the grassroots of this, or the practices amongst particularly young people, they sort of look at us blankly and go, what are you talking about here? But the issues around teen sexting are an interesting legal history lesson, and I will be bringing up some names from the past in looking at that, but also the position we're in terms of the legislative conflict between the protection of victims from the adult space and the potential criminalization as victims from minors in these sorts of situations, and how there have been attempts to try and address those issues while not addressing the fundamental issue, which is that the legislation wasn't developed for how it's being used now. So sometimes I sort of refer to as sticking plaster solutions, and then looking forward. But I should stress, in terms of talking about this from a responsible perspective, I am going to be talking about issues of some issues of abuse, and I will be referring to some things around sort of sexual content and sexual discourse and similar. So I will place a trigger warning at the start of it. If people are personally affected by any of the things I mentioned, you are, as I said at the start, very welcome to contact me. While I'm not a a trained counsellor myself. I do work across the networks with a lot of people who are. So if people are personally affected, we can sort of help. But I just think it's a responsible thing to do right at the start to bring up the fact that there might be triggering topics that we're talking about here. So just to start off with, this was Oliver Dowden, who's Secretary of State for Digital Culture, Media and Sport. It was his piece in the Telegraph from a couple of days ago to herald the response to the consultation on the release of the Online Harms White Paper, which of itself was a springboard from the Internet Safety Strategy Green Paper. So this has been swirling around in the policy space for quite a while now. There has been considerable pressure from both the opposition and NGOs, folk like the NSPCC, to say, all right, so we've been talking about this for a long time now. When's it coming? So this is, if you like, a little bit of a stopgap before actual draft publication of bills and actual statement of legislative intent is clearly articulated. But I'm not going to dwell too much on the content of the response. There are many talks that could come out of the content of that response. I'm sure I could spend the next 2 or 3 hours talking around the political discourse of demands for a reduction in end-to-end encryption in communications and placing backdoors into end-to-end encryption, and which has almost entirely been triggered by the fact that Facebook have said that they are going to place end-to-end encryption on their Facebook Messenger platform. And you just know that politicians are on their WhatsApp groups discussing how problematic end-to-end encryption is. It's just it's an interesting discussion to be had, and it again demonstrates that policy sometimes fails to learn from history. So some of you might remember the crypto wars of the 80s and 90s. But what I want to really sort of reflect upon from the online harms agenda is the discourse and the rhetoric that's used within it. Once again, we're talking about Britain leading the way and how we're going to establish a legislative structure that is world leading and that the whole world can follow. We're introducing a new age of accountability, all of which strikes me as a little bit peculiar given the change in industry response, granted as a result of a lot of policy and NGO pressure over the last few years. Certainly, if I was doing this sort of talk about 10 years ago, I would be very clearly criticizing industry and saying that they're just not doing enough. These days, I find myself a lot of the time saying they can't do it all themselves. We talk about the big platforms and they provide effective reporting now, and they provide effective strategies for safeguarding and similar. But there are some things that technically just aren't possible, and it seems the focus of this online harms strategy is entirely on placing the responsibilities entirely in the hands of the platform providers. Now, these are technologically facilitated issues, but they are ultimately social issues. There's nothing new about the exchange of an intimate image. It's just that technology makes it a lot easier to do. I'm sure some of you would remember the Polaroid camera from the old days. One of the major selling points of Polaroid cameras was you wouldn't have to deal with the crushing embarrassment of taking a film full of intimate images down to Boots to have them developed. So they sold off the back of those sorts of intentions. It's just that these days technology provides you with the means to take a lot more images and distribute them a lot faster. But the social behavior is something I sort of reflect upon in the book I produced on the topic. It literally does go back sort of to the beginning of the 20th century. The other thing I want to reflect upon in terms of the discourse, though, is the language used is very inflammatory. Now, the darker side of the web is something that's come from the political scene, really from David Cameron's time when he was talking about porn filtering and that folded into age verification on porn sites and similar, and that piece of legislation got withdrawn last year. As a result, in a lot of one of the main reasons as a result, because technically it was almost impossible to achieve, particularly when you spoke to 14-year-olds who talked about using VPNs to bypass any geographic processing of an IP address. But this idea that the web has a darker side, and you start from a position of there's illegal content on the web. There clearly is illegal content on the web, and folk like the Internet Watch Foundation do a fantastic job in policing that sort of thing. But it's when you start to get into what's referred to in the policy documentation as harmful but not illegal, or what damaging disinformation is. So Labour a couple of weeks ago called for criminal proceedings against platforms that provided anti-vax misinformation, which does immediately have a pushback of how do you actually define that, given that there were a number of politicians that were posting misleading information on some platforms about how the way we got vaccination done more quickly was because we Brexited, which wasn't the case at all. So is that misinformation? Should they have been taken down for that? But I think the other thing that very strongly comes out in all this online harms discussion is very much the focus on child harm, and the fact that young people need to be protected from the perils of the darker side of the web. It's a very difficult thing to push back against. If you're saying, well, children are being harmed, if you support this, we might be able to do something that will prevent children from being harmed. If, for example, you take the end-to-end encryption discussion around Facebook Messenger. Facebook Messenger is used in some cases for the exchange of child abuse imagery, because Facebook can intercept those messages, they can identify those images. If they place end-to-end encryption in there, that won't be the case anymore. Therefore, are you opposed to end-to-end encryption because paedophiles use it? Well, yes, they do, but also I was in a college yesterday talking to a bunch of students about this and said, well, does anyone fancy buying anything online without end-to-end encryption? But that sort of rhetoric, and those on the call might be aware of the four horsemen of the apocalypse as an example of how government convinces buy into these sorts of things by saying this is something that's used by terrorists, or this is something that's used by paedophiles, or this is something that's used by drug dealers. Do you think this is a good thing? So it's just an interesting rhetoric that is very strongly being driven from the online harms agenda at the moment. But just to sort of move back to the focus around image-based abuse, I'm going to talk about the adult space first of all. Now, I work with an organisation a great deal called the Revenge Porn Helpline. They basically support victims of image-based abuse. So they will be contacted by someone who says there's images of me out there. Someone's posted this up onto, for example, a pornography site. Someone shared this with friends and family. Someone's posted this on social media. What can I do about it? I don't know what to do about it. But one of the things that very clearly comes through quite strongly when you sort of look at victim statements and something in this area is the feelings of isolation, the feelings of helplessness, the feelings that they will blame themselves for these sorts of things. I'll sort of come back to that in a moment. But as with an awful lot of what we broadly refer to as domestic abuse issues, and this is clearly in a lot of cases a domestic abuse issue, we are seeing sort of an uplift in those sorts of things during lockdown. There's also, because there's an increased use in online dating platforms and similar, there's been reporting rises in maybe the exchange of images on those platforms, leading to further levels of coercion or pressure to provide more images, for example. Otherwise, there will be threats to share further. Now, on the flip side of this, again, when we planned to schedule this talk at this time, we didn't know it's going to be such a busy week for these sorts of issues. But on the flip side of that, we have seen in the last week that Pornhub have removed approximately 80% of their content. Now, while this is a Daily Mail headline, and Daily Mail will generally take quite an excitable perspective on these sorts of things, saying that Pornhub was hosting child abuse material. Clearly, that was the case, but equally, they hosted a huge amount of unverified what we might refer to as revenge pornography, where people would create accounts and upload images and videos of ex-partners and similar. And about the best that both Pornhub and Xhamster and similar would offer is protection under Digital Millennium Copyright Act and similar, where if it is self-produced material, you do own the copyright on it. So if you can demonstrate that it is you in these videos, then we will take them down, which is an appalling level of re-victimization. And as a result of a great deal of pressure, and also MasterCard and Visa withdrawing their financial services because of the reputational damage being associated with these platforms, Pornhub did announce this week that they were going to pull all unverified content, which is actually massive, and also demonstrates how the difficulties these providers find in managing this sort of content once it starts to become introduced onto their platform. So they made the strategic decision just to pull all of it rather than just pulling the stuff that was posted in a non-consensual manner. So it's been incredibly timely to sort of look at that this week. It's interesting to see what's going to happen from the major pornography providers, because obviously Pornhub is only one of several, but we would imagine these things will follow suit, because we know through our work with the Revenge Pornography Helpline that a lot of this content does end up on pornography sites. I use the term though, but I find the term really quite problematic. Now Jeff McAllister from McAllister Oliverius, who've done some fantastic work in this area, sort of came out with this definition a while ago. It's basically the non-consensual publication of explicit material. I'd probably use the word intimate rather than explicit there, but it is specifically the non-consensual sharing of this media. The reason I find the term quite problematic is because it almost implies that there's a justification for the act. A lot of this stuff happens as a result of relationship breakdowns and similar. So a relationship breaks down, and one of the people in that relationship decides that they are going to get revenge on the party that decided to terminate the relationship by taking intimate images, intimate videos, and sharing them and posting them. It doesn't seem like a reasonable, justified behavior to say you've broken up with me, therefore I am going to post a lot of intimate media about you in places where everyone can see it. It doesn't seem to be a justification at all. So the term revenge really is quite problematic. The other side of it is that when we refer to it as pornography, pornography is defined as something that is intended to generate sexual excitement. Looking at the Revenge Porn Helpline casebook, talking to police, probation officers, similar about these sorts of things, there is very rarely a sexual motivation for doing this. It is generally done to harm and abuse, which is why it is far more comfortable to place these sorts of things into the terms such as non-consensual sharing of intimate images, image-based abuse, looking at it in the context of wider domestic abuse as well. Again, talking to police and probation officers around this sort of things, they talk quite frequently around the fact that the actual act of non-consensually sharing is not in isolation. It's done within measures of harassment as well, measures of further abuse and those sorts of things. It's not done as a single act. Now, prior to 2015, legislation was mixed in this area. You had harassment laws, you had malicious comms laws and similar, but it's to the credit of the government at the time really there was a lot of drive from the Revenge Pornography Helpline to look at the legislation, and they did introduce into the Serious Crime and Courts Act a specific section that looked at addressing the disclosure of private sexual photos and films. The legislation, as stated there, is a step in the right direction, but not without its own problems, specifically the intention to cause the victim distress needed to be proven. There are also jurisdictional issues. There's also the fact that threat wasn't in there. If you look at the comparable Scottish legislation, in the Scottish legislation, the threat to share intimate images is also part of the legislative definition, whereas with the Westminster legislation, that's not the case. Because of the intention to cause distress, there have been, in some cases, defence where they've sort of said, well, they can't be found guilty because they didn't do this for revenge, or they didn't do it to cause distress. They did this for financial gain, for example. So that has caused some problems, and the Law Commission, which is doing quite a lot of work in the online space at the moment, is currently consulting on revisions to legislation. It's covering a great deal of different topics there, so pseudo-sexual imagery, looking at intent and whether intent should be proven or whether impact on victim is sufficient, looking at issues around threat, and also trying to keep up with the technology, because one of the challenges that this legislation has is, well, legislation in technology areas at all, or tech policy in general, is keeping up with the technology. So how do you address live streaming? Even things like how do you address drone footage, for example, where you have individuals hovering drones with video cameras outside of bedroom windows and similar. Now, it's how do you actually phrase a legislation to actually address all of these issues? When we reflect upon victim profiles and similar from discussions with the Revenge Porn Helpline, one of the things that very strongly comes across, and one of the things that they talk about a great deal, is that we need to stop talking about a typical victim. While 75% of the helpline victims are female, and female victims are more likely to be subject to sexual extortion or abuse or coercion as a result of this, this is not uniquely a female victim crime. Men are more likely to contact the helpline as a result of financial extortion. So the classic being befriended on social media and then being encouraged to engage in sexual activity on a webcam, then being contacted to say, we filmed this and we're going to share this with third parties unless you give us some money, or financial extortion that's come from an ex-partner. There is not a typical victim, but there are some typical responses from victims, which generally are around self-blame, exasperation, and an assumption that nothing can be done about these sorts of things. Now, I'm going to come back to this very strongly towards the end when I look at the education space in this area, but what we see is the sorts of punitive educational messages that are delivered in schools, such as don't do it, it's illegal, once it's online, it's always online, you shouldn't do this sort of thing, are then spoken from the mouths of victims within the Revenge Porn Helpline. So adults that have probably been through this school system will definitely look to blame themselves in a lot of these cases, and not say, well, I exchanged some images with someone I was in a relationship with, that person then decided to distribute them further. He's completely out of order, she's completely out of order. I'd like the full force of the law to be brought on them. They will still blame themselves. One of the other interesting things is that while we have in legislation this definition of intimate, we do see cultural variation as well. So in some cultures, intimate can be far less explicit than it is in others, and sometimes something that might be considered explicit in one culture isn't enough to trigger a concern. But in terms of, is the legislation biting, we can certainly see that this is from Ministry of Justice crime stats, which I spend far too much time looking at, but it is a very reliable source of where people have been proceeded against in terms of charges and similar. We can see that across the board there have been application of this legislation quite early. I mean, from the legislation coming onto the statute, I think it was only a couple of months before there was the first successful prosecution. There is clearly a need for this legislation, and the legislation is being used. What's slightly more concerning is the fact that this legislation is being applied to minors as well, which starts to get me in the nature of the legislative soup in which we are currently stuck because the legislation would suggest that this is for adult victims, particularly because there is different legislation that looks at the distribution of intimate images amongst minors. So it seems interesting and concerning that this legislation is being applied to minors as well. But I will move on now to the classic sexting or sexting amongst minors. I'm going to use the term because it's something that has been stuck in my vocabulary for a long time. The headline on the left is actually a Daily Mail headline drawn from a piece of research I did with the NSPCC back in 2012, where the conclusion of that research was specifically, this is not an epidemic, this is a minority of young people engaging in this. However, as a result of the exposure of these images, young people are generally exposed to it, whether or not they want to see the images. So clearly the Daily Mail then takes that conclusion and decides that it actually is an epidemic, rather than what the report said, which is specifically it wasn't. Interesting, they also quoted statistics from the report, which was entirely qualitative and had no statistics within it, but that's just the nature of media reporting in this area. It's something that attracts a great deal of media attention. It's something I've spent a lot of time looking at. It is something where we're seeing a trickle down of behaviours where in rare cases you will find very young children engaging in these sorts of activities. That is not the usual scenario, though. The usual scenario will be this is the sort of thing that happens amongst teens. I will come back to sort of like the work I've sort of done in this area over the years, because it's something I have spent a lot of time doing over the years. But the concern from a social perspective, and also in terms of the application of the law, is what we started to see. We started to see this as a, if you like, a phenomenon back in sort of 2008, 2009. We'd visit schools. The schools would say they've had a sexting incident. They don't know what to do about it. They would be bizarrely reassured to hear that this isn't unique to their school, and we work with other schools where this sort of thing is happening. At the same time, we were sort of doing some light lobbying, suggesting this is something that needed to be looked at, and politicians would generally dismiss it as, you know, it's just something that happens in extremely rare occasions, where actually it was the case that virtually every school we were visiting, they were talking about how they deal with sexting incidents. But we were seeing a growing number of young people being charged as a result of taking these images and sharing them. So not the person who received the image and shared it further, but the person who actually took the image in the first place. Because it is correct in these headlines, by the letter of the law, that person who has produced and distributed that indecent image of a minor is breaking the law. However, and this is something I'll go back to again, we are sort of toward the second half of the second decade of the 21st century in a bizarre situation where if you were aged 18 and you took intimate images of yourself and shared it with someone who then chose to share it further, you would be protected in law. However, if you were 17 and did exactly the same thing, you were potentially going to be criminalized as a result of taking indecent images of a minor, which seems to be utterly counterproductive and really quite problematic. As I said, I started this work early. We did some survey work back in 2009. We were aware it went on, but what we didn't say to young people is, do you do this? Because obviously then you're asking them to disclose that they are engaged in illegal activity. We didn't want them to do that. So we said, are you aware of people that do this? Interestingly, we piloted this work with a couple of schools. And even back in 2009, we're saying, oh, we want to do some work on sexting. And they went, well, what's that? You go, well, it's sending of intimate images. They go, oh, yeah. You go, okay, so you're familiar with the practice? They go, yeah, a few people do it. Even back in 2009, the difference between the adult stakeholder and the young people's awareness and also attitude towards it was starkly different. Even back then as well, in the majority of cases that these young people were aware of, they were saying it would be distributed further. And in 3/4 of those respondents, they were saying, well, you know, we can't see any we can't see that that was done in a nasty manner. That's something that just happens, you know. If you don't want that to happen, don't send the pictures in the first place, which does pose the question on why you would choose to share intimate images of a peer with others if it's not to cause upset. But we sort of continued with this work for well over 10 years. Over that time, and I returned to this last year because I just wanted to sort of like just see whether attitudes and similar have changed. Over that time, nothing has changed in terms of the education space or young people's attitudes to it, or how adults with safeguarding responsibilities respond to it. When I started this work in 2009, I said, what can adults do to help? The three classic things were listen, understand, and don't judge. When we said that 10 years later, they came out with exactly the same things. It is something where, as adults, we find it problematic when we hear about 13, 14, 15-year-olds doing this. But from a social perspective, we need to acknowledge the fact that it does happen in the same way that adults do this. I've not been on Tinder myself, but I am told that, you know, it is not unusual if you're on Tinder that within a few message exchanges, someone's genitals might appear on the screen. You know, it just seems to be something that society has adapted to in terms of digital technology, and we can go off on a theoretical tangent around the social construction of technology and similar, but it just seems to be the case that this is the case. And the counter argument to why are young people doing this is, well, why wouldn't they if this is what the adult population do? But I'll come back to education in a little while. But certainly the focus of concern is very rarely on the victim. In the case of distribution being shared further, it's generally, well, if you hadn't taken the pictures in the first place, they wouldn't have been able to share them, would they? There's quite a famous case in Plymouth from a few years ago where two 14-year-olds were charged for distribution because one of them sold 70 images of his 14-year-old ex-girlfriend to his friend for £10. And in that case, I think, you know, the law was correctly applied. But when you looked at the social media traffic around the reporting of that case, the vast majority of the response was, well, if she hadn't taken those images in the first place, then he wouldn't have been able to sell them. And it's terrible that these two people have been charged because now their lives have been ruined because of what she did. It does seem to be a strange social perspective to take on that sort of thing there. And it's something that is not unusual to that one case or the reporting on these sorts of things. But one of the things that is very clear, because we talk about disclosure, so you sort of take the hypothetical situation. If you've shared images and they're being shared further and you're being coerced or you're being extorted or you're being abused as a result of it, would you talk to an adult about it? And the general response is no, because it's illegal. Well, who's been talking to you about the legalities of it? Oh, we had a policeman come into an assembly to tell us about the legalities of it and those sorts of things. It is a frustrating situation because the messages, the educational messages are, if you do this, it's illegal. It means someone who is being abused or being coerced as a result of doing this is far less likely to disclose about it. And then if you reflect on this rather amusing conversation I had with a young man a couple of years ago now, where, you know, just trying to get to grips with the unsolicited dick pic. I find someone attractive, therefore I'll take a photograph of my genitals and send it to them, and then maybe they'll go out with me. Which, as bizarre as it sounds, it seems to be, you know, one of the views of how you form a relationship. But then if you reflect upon the fact that relations with education within the UK is particularly poor, then you can see where they might get these attitudes from. But this was a short conversation I had with a young man who was 14. So I said, you know, so why do boys send dick pics then after getting a new back? They say, well, no, never. And then you say, so why do it then? Because one day it might. So what you've got here is a young man talking very openly about the fact that this is how his peers think you form a relationship, or you might get an image exchange as a result of it. But what he's actually talking about here is engaging in illegal activity, and I'll come back to cyber flashing right at the end, but talking about engaging in illegal activity where as a result of that, police might be called, there might be an arrest and similar, but they're doing it because they're trying to form a relationship. They're not doing it to sort of engage in it because it's risky illegal activity. But the legal protections go back a long time in terms of the legislative or the law around it. So for those more senior members of the audience, you might remember the obscenity campaigner Mary Whitehouse, who was actually instrumental in the implementation of the 1978 Protection of Children Act. Now, if you explore the Hansard debates at the time, it was entirely focused on the criminalisation of adults who exploited children in the manufacture of pornography or the production of child abuse material. There are no discussions, unsurprisingly, in 1978 around the fact that, well, you know, in 40 years' time, we'll have devices, which means you can easily take a photograph of yourself. What happens if the taker of the image and the sender of the image is the subject of the image? Funnily enough, those debates were not had in 1978. It was very specifically about the protection of children from exploitation by adults. And that is basically the legislation that still stands. There was an update in the Sexual Offences Act just to bring the age of a minor in these cases to 18, in line with age of majority, because in the Protection of Children Act it was 16 and under, and in the Serious Crime Act there was an introduction of an offence which again took a long time to be enacted, and the NSPCC very much drove the lobbying for the enactment of this around making it illegal to communicate in a sexual manner with a child. Now, because of the increased coverage, particularly in the media, of young people being charged under this legislation as a result of engaging in the self-production of intimate images, the CPS did bring out guidance, and the CPS did say very clearly it's really in the public interest to prosecute a minor. At the same time, the UK Council for Child Internet Safety was releasing guidance suggesting to schools that if you were dealing with a case of intimate imagery among peers, as long as there was no evidence of coercion or exploitation, it's probably something that should be dealt with in the school environment rather than involving the police, which again, because of the legislation, presents something of a challenge to the school, because by the letter of the law, it is an illegal act, so they should be disclosing it. But we also know that as a result of this, arrests were being made. So if I'll come back to arrests in a moment, but if you look again at the Ministry of Justice stat, this is consistently over the years, young adults and minors themselves have been subject to proceedings against as a result of arrests under Section 1 of the Protection of Children Act. There was a peak sort of 2015, 2016 for reasons I'll get onto now, but clearly this is a case where young people can potentially end up with a criminal record as a result of doing it. Now, as a result of the fact that it was becoming pretty accepting that the legislation isn't really fit for purpose, and a great deal of pressure on the CPS and on police, the College of Policing did release a statement toward the end of 2016 talking about how Outcome 21 recording might be used in the case of youth-produced sexual imagery. Because police up to that point, quite rightly, were saying, well, if a crime has been reported, we need to record it. And whether it moves to prosecution or not, the arrest and the charge needs to be made. So this was argued that it was a way of addressing that need without the need to change legislation. So basically what they're saying is if it's non-abusive, there's no evidence of exploitation or malicious intent, then record it an Outcome 21, which basically says no further action, no public interest. Therefore, we've dealt with the issue, but no one's going to end up with a criminal record as a result of it. And it was viewed as a positive step forward. However, anecdotally, we were becoming aware that the Outcome 21 recording seemed to be being used quite a lot across some forces, and equally it seemed to be being used in an inconsistent way. Now Professor Emma Bond at Suffolk University, who I work with a great deal, had done some work previously with a number of police forces asking about training around image-based abuse in general, so both teen sexting and also revenge pornography. And her finding was that in most cases, in about 95% of cases, they'd never received any training in this area whatsoever. So it should come as no surprise that these pieces of legislation and these responses to legislation were being applied in an inconsistent manner. But we were asked by the Mary Collins Foundation, who look at support for victims of online sexual exploitation, online child abuse, and similar to because the concern of the chief executive of the Mary Collins Foundation was that young people were still being criminalised in, if you like, a soft criminalisation rather than being charged. So we put in a brief of information request specifically looking at Home Office Code 86.2, which is for referring to the making and distribution of indecent images of a minor. We also wanted to look at how often it's used for not very young, but slightly younger teens, because we were aware that this was being done by younger age groups. So we wanted to sort of look at the statistics on that. Now, there is a link at the bottom to the full report, and like I said, I'm really happy to share these slides with whomever wants them. And these police forces here are just used as a random sample. It's not that these are the worst forces we got responses from, but what we're demonstrating here is that this stuff is still applied in a fairly inconsistent way. So on the whole, we do see that the number of arrests under this legislation has reduced. We can see it in the Ministry of Justice stats as well, that there has been a reduction. But what we're also seeing is, in some forces in particular, there are a huge number of Outcome 21 recordings being carried out. Now, the problem with Outcome 21 recording is that while the individual doesn't end up with a criminal record, it's very clearly defined that in a DBS check or an enhanced DBS check in the future, at the discretion of the Chief Constable can still say that the Outcome 21 record should be disclosed in terms of criminal activity. But what we're concerned about is, because that's poorly understood, and it's a good way of shutting down an investigation or a longer police process. It's almost kind of like, right, this has happened, you've called us in, we're going to call it Outcome 21 and leave it at that, without actually reflecting on the fact that it still can cause sort of long-term implications for the individual involved. And you know, if you look at Greater Manchester Police there, where they had this was from the end of 2016 to 2018 in this case, they had almost 500 Outcome 21 records against under 14s for this sort of activity. It does become a significant concern, because the implications of all this is that, you know, for the best of intentions, the legislation is it was not defined for the purpose of which it's being used now. However, the counter argument is, but yes, that's the legislation, and if the law has been broken, then we shouldn't be worrying about the social context of it, which is why Outcome 21s came along. But it still can be returned. And the point I made earlier, which is the fact that at the age of 18 you're protected in law, at the age of 17 you are potentially criminalised as a result of it. It does seem to be a bit of a mess. However, as part of the Law Commission review into image-based abuse, a number of us did bring up the fact that while it's admirable that we're looking at, for want of a better word, revenge pornography legislation, we need to look into the child space as well, because it's just a complete mess, and we were very clearly told there is no political appetite to look at this. But just to finish off, I said I want to sort of return back to online harms and the drive for industry to address these issues. Now, I'm going to talk a little bit about something that Jeremy Hunt said in a parliamentary inquiry a few years ago now. It was still when he was Secretary of State for Health, and it was an inquiry into young people's mental health and suicidal ideation. And he came out with this statement because he was talking about the fact that, you know, the sharing of sexually explicit images can be something that's harmful for young people. It can have a detrimental effect upon their mental health. They can be sort of abused as a result of it. So he just came out with this statement here, you know, well, why can't we just put an algorithm on their phones to stop this from happening? And my concern with these sorts of things, and it's, you know, it's not just the case that this was one phrase. If you look through the online harms response, it's all over the online harms response. Technology companies need to sort this out. Technology companies need to sort this out. But if you just sort of unpick what Jeremy was saying there for a moment, technically, it presents a great deal of challenge. So preventing the sending of images, what are we actually talking about here? Are we talking about a message-based platform? Are we talking about email exchange, airdrops, Bluetooth? What is it exactly? While we might say we know if the user of a device is under the age of 18 because of the contract, there's a huge amount of pay-as-you-go phones knocking around. There's a huge amount of parental hand-me-downs. So how do we know that the user of the phone is specifically 18? But when you have statements like we have the technology to identify sexually explicit images, that starts to become a little bit more problematic given that image recognition generally relies upon training sets to do it. So if we're talking about identifying sexually explicit images of children, the training set should be surely sexually explicit images of children. And quite rightly, we don't allow companies to host those sorts of images, and it creates a massive ethical dilemma. There are police systems that use image-based recognition techniques. There's a big one in Australia. I find it really problematic because obviously these are scenes of child abuse, and no one's consented to those images being used. But it is really concerning, and the whole sort of AI discourse at the moment is AI is going to solve everything. Now AI is fantastic at certain things, but it's not fantastic at other things. But really, we're getting into very much an agenda of private sector organisations having to engage in more and more of these sorts of things to make judgments on behaviour from an algorithmic perspective, because the legal side of things isn't really fit for purpose. And really, when you sort of like start to go through the online harm stuff in more detail, it really is just another catalogue of this is a harm, industry needs to sort this out. This is another harm, industry needs to sort this out. And I think in the teen sexting space, it's been extremely evident for a long time. There are apps now that are sold to parents that say that they can detect this sort of thing. My concern with those is what happens when a false positive is triggered. It's quite problematic. So really, where do we need to go with this? Now, I said at the start, it doesn't feel, as someone that's been immersed in it for the last 15 years, that things have really moved on very much at all. The all-party parliamentary group on social media has recently launched an inquiry saying basically what's behind the rise in self-generated and indecent images of children online. Really, are we still asking these questions? Because we know it happens, and we know the motivations are generally, for want of a better word, quite innocent. It's the exchange of images amongst peers that then get shared further. It's the sharing further we should be concerned about. But why are we still asking these questions rather than asking questions like how does the law need to change, or how might we support young people better who are abused as a result of this? Now, if you look at the Law Commission current consultation on harmful online communications, cyber flashing is included as a proposed piece of legislative change. Cyber flashing generally is referring to the entirely unsolicited dick pic that appears on someone's phone or it's dropped on someone's phone. The examples are normally given is things like, you know, someone is sat in a train carriage and someone notices that their Bluetooth is on, so they decide to drop a dick pic onto a phone to upset, to harass, to abuse. So quite rightly, we need to be looking at this in terms of harmful communication. But equally, there's no consideration of age, and I can just imagine in 2 or 3 years' time, if this legislation does come into being, that in the same way that the Protection of Children Act is used as a punitive threat to 13 or 14-year-olds, then the issues around cyber flashing will be used in exactly the same way. And we've got this cloud of duty of care hanging over the whole debate around this area at the moment. It would be lovely to see something a little bit more tangible around what this is, in order that industry might need to be able to do something about it. But I really do think now I think it's important from an industry perspective to actually do a little bit of pushing back on some of these things. Again, we can't solve everything. Some of these things are social issues that are facilitated, that are manifesting in technology, and we can provide reporting, and we can provide responsive, transparent reporting, and we can provide the tools to block abusers and those sorts of things, but we can't do it all. And the education space in this area is so painfully weak. We are seeing young people going through the school system ending up blaming themselves when they are a victim of image-based abuse, because those are the messages that have been delivered. The education space really needs to change, and the thing that was incredibly loud in its silence from the online harms response was the fact that education is hardly mentioned at all. It's viewed as something that technology is going to solve, when really it's not going to. So I shall end there. I'm very happy to take a few questions now. Like I said, people are welcome to email me in the future, and for those of you that are dropping off now, Merry Christmas as well. Thanks.
Thank you very much, Andy. Excellent presentation. I don't seem to have something in the chat, all the questions. So I would like to ask the participants to raise their hands if they want to ask you something, and then I will unmute them and they could be asking a question to you. We'll give okay, I can see a raised hand. So let me. Okay, Stephen and Elana, I will unmute Stephen.
Yeah, okay. Can you hear me? Because it often doubles.
Yes, yes, can. Thanks,
Just
Stephen.
just about.
So, I did put a question on the chat to get the first one. Has it not come through?
So, Stephen, we can hear you. Your voice is a bit deep. Would you like to raise your question?
Let's just go through a webinar. It always doubles it. Forget it then. I'm just saying I have put a question on the chat, the second question. Okay.
No, I can see nothing in other chat, all the questions at the moment.
Yeah, there is none in the chat. Would you like to ask your question, Stephen?
Yeah. The technology is like, can you hear me?
Just about.
Yes, we can.
We'll see.
I did put a question on the chat, I put two, but forget the first one. That's all I'm saying, which was picking up your last point. Can you still hear me, or is it guarded or distant?
I can just about make you out to keep going, and I'll see whether I can hear the question.
Okay, the technology solution. We need to have it at the point of actually taking the image in the first place. That's where you need the AI. So what I was suggesting is an AI app that doesn't even allow you to take any photograph subject to certain rules or statutory controls. So you actually control cameras in the first place. Now that knocks on to the whole rough and ready law we have, which is not really accommodated the invention of the camera in the 1850s. We do not have clear law about rights to privacy, about what should or should not be anyone's right to take a photograph of somebody else. It is not clear. It is rough and ready still, and yet it's nearly 200 years, sorry, not 200, it's nearly 200 years ago, the invention of the camera. We still are not grappling with that technology in terms of rights to privacy, of controlling who can take a photograph of what by this thing called a camera. And I think that's the problem. It's taking the image in the first place, not what is then done with it.
But I'd very much agree that it's something that really hasn't been addressed for a long time, and you know, the best they got near is basically say, well, if you take the image and you're in the image, then you own the copyright on it. But I really don't think copyright is the best solution in this area at all. You know, it really should be considered to be abuse rather than, oh, you own the copyright on that image that's now being used to abuse you. So no, I very much agree.
Well, the copyright is not for intellectual property. We're talking about a right of privacy. As soon as you say that, you realise that that's a wholly undefined thing. It just generates discussion. There is no right of privacy, and yet we all think there is a right of privacy. What is it? After 10 years, you get 10 different answers.
I think the connection dropped off quite a bit at the end there. I missed the last.
The connection is not very good, Stephen, and the last bit we couldn't hear. Would it be possible to put it in the chat?
It's a webinar that's rubbish. I never have the problem on Zoom, on BeerJeans, on Skype. It's always a scheduled webinar. Anyway,
Okay.
somebody else asked a question.
By all means, send me an email though, Stephen.
Elaha has also raised her hand, so I will unmute Elaha, and then could you raise your question, Elaha?
Yes, sure. Hi, Andy.
Thank you.
Can you guys hear me okay?
Yeah, that's really clear.
Yes.
Perfect. Thank you, Andy, for the very useful talk. I've attended a few of your sessions in the past as well, and it's always great to have you cover these topics. I actually work for Refuge. You may have heard of us, and I work predominantly with young people on tech facilitated abuse. So I really like that you covered a little bit. You linked it with domestic violence. So my question was, I also popped my question in the chat, but I think you can't see it. So what I wanted to ask was about outcome 21, because it's quite unclear for me still as to how that works. From my understanding, young people between the ages of 16 to 17, they are given outcome 21. But does it apply to perpetrators, those who have distributed an intimate image, but also to victims who have taken an intimate image and sent it to the alleged perpetrator, who then goes and distributes it further?
This is one of the issues with it, is really that guidance isn't clear at all. I think the honest answer to that is it can be applied to any of those situations, but it is implied in an extremely inconsistent, and I mean we use the term postcode lottery excessively, but I think in this case it literally comes down to whether the PCO that's visiting the incident or visiting the school where the incident has happened, whether they first of all take it seriously, secondly whether they've received any training and similar. So for both outcome 21s with minors, but also in the adult space, when you talk to the RP helpline, they say sometimes the victim's greatest frustration is with the response of law enforcement because it is so inconsistently delivered. So outcome 21 can be applied, it's not just 16 and 17. We've had many examples through the freedom of information work where you've got 12, 13, 14-year-olds receiving an outcome 21 as a result of this sort of thing. Sometimes it will be for the sharer, sometimes it will be for the victim. It really is as inconsistent as that, which is why when it's argued that, but we don't have to worry about the Protected Children Act anymore, we've got outcome 21, therefore we're not criminalising them anymore. You kind of go, yeah, but look at it, 1/4 they're applying it 1,000% more than they'll do arrests. Some forces they're not applying it at all. It's really very frustrating, and the law that was designed to protect children is now being in some cases used to criminalise them, and that really is terrible. But like I said in the talk, if by the time I retire, which is going to be in about 15 years time, the law has actually been changed, I can put my feet up and think I've actually achieved something. But whether that is the case, I don't know.
Perfect. Thank you so much.
Pleasure.
Thank you, Ella. I will just give another try to unmute Stephen. Maybe it's clearer this time. So, Stephen, would you like to give another go?
I think he's gone.
Yeah.
Can you hear me better?
No, it's as bad. I think, Stephen. No worries.
Go through webinar is rubbish, basically. I never get the Zoom and Skype, I mean, Blue Jeans or anything else. It's always just go-to webinar. BCS insists on leaving.
I think I might use my department's Zoom platform when I do another one of these again. So, but you know, it's
okay. So I do not see any more raised hands. I seem to have nothing in the chat. I sent a test message to all just now, or the questions. I would like to make a last call in case somebody else wants to speak, to raise the hand, and then I will unmute. Right, I don't see any more hands raised. So I would like to ask Professor Andy Pippen for his presentation. It was a brilliant presentation, very excellent coverage of the topic, and I would like to invite you all back in January. It will be our chair, Sam Da Silva, who will be presenting the next event, and it has to do with software licensing. So I would like to invite all to the January event. The date is not precise yet, but we will know soon. It's also unfortunate that we couldn't be physically meeting each other and discussing this face to face, but also via the virtual way there can be events and excellent events. So thank you all, have nice holidays, and see you in January with our next event. Thank you very much.
Thank you.
Thanks also, Stephen, for the question. Thanks, Andy.
Thank you. Cheers. Happy Christmas all.
Happy Christmas. Bye.